Think we're on the being recorded now, or soon will be. This is case number 127849 in the Court of Appeals of the State of Kansas in the matter of the marriage of Maria Fernanda Castillo, appellee, and Ildeberto Castillo Alvarado, appellant. I would ask counsel to please enter their appearances.
May it please the court, the appellant appears by counsel Aldo P. Collar.
May it please the court, Timothy Olson on behalf of the appellee Maria Fernanda Castillo.
And counsel, as I understand it, the parties are not here. They will be appearing through counsel, and we have no need of an interpreter today. Is that correct?
That is correct, Your Honor.
All right. Now, Mr. Collar, do you wish to reserve any time for rebuttal?
Yes, I would like to reserve 5 minutes.
Very good. I'll do my best to get that reserved to you. And give me a moment. All right, you may proceed. Thank you, Mr. Collar.
You may please the court. As stated in the appellant's brief, this is a rather unusual case in that it shows that during a trial in a divorce proceeding, my client, the appellant, faced a situation that was very obviously not one that he was at all competent to handle. And really what the case boils down to is that the court, we believe, should have afforded him an opportunity to just have a continuance to obtain counsel. But the way that the proceedings took place, as reflected in the brief that we submitted and in the record of the trial itself, it devolved into something that was more like a browbeating of the respondent, in which he was asked repeatedly whether he was ready to proceed. Are you ready to proceed? Yet he was never given the option. If you are not ready to proceed, this is what will happen. If you are not, opportunities in which he expressed to the court essentially that he was not ready to proceed. He said, I've tried to obtain counsel, but couldn't. And instead of the court evaluating that response as a plea for, or a recognition that he was not ready to proceed, the court rather questioned him about it. Well, you just don't want to pay an attorney. The court had absolutely no basis for making such comments. And there were other comments that are also pointed out in the brief that show that the court perhaps had some bias against my client for whatever reason. Perhaps what took place during the status conference in September of 2023 may have created a bias on the part of the court, but the court definitely, it appears, showed an unwillingness to hear what the respondent had to say as far as his preparedness to go forward and represent himself.
Stop you there, okay. In the record, I'm looking at it from the November 1st hearing, 23. Court asks him about an attorney. The court advises him he says, I want you to understand, I want to make sure you understand you're representing yourself pro se, correct? And he said, yes. In the court, which means that you need to know the rules of evidence and the rules of civil procedure like an attorney does. Do you understand that? And your client said, I don't know. I tried to get an attorney and they just want to take my money. The last attorney was one of my money never came. So I'm going to ask you, doesn't the record point out that it is your client who has stated the concerns of paying for counsel, and that's why he has not been represented by counsel that day?
We believe so. I think he was trying to express that he tried to obtain counsel. He was in that process, but had failed. And that was in direct response to a question that said, are you ready to proceed? Do you understand that if you proceed, you're going to be treated as an attorney? He never did say, yes, I'm ready. I know the rules. He just kept saying, I've tried to obtain an attorney, and the response he got back from the court was, no. It's you just don't want to pay for one. You consider that you're a difficult client.
I'm going to interrupt you again because the record says, I tried to get an attorney and they just want to take my money. So I'm going to disagree with you on how the court responded, because it is your client who says they just want to take money. How am I supposed to reconcile that from your own client's statement that the attorneys want to be paid?
Yes, attorneys want to be paid. And he is telling the court that he has tried, but attorneys just want to take his money, but not provide him a representation based on the experience he had with the attorney who was allowed to withdraw, who showed up once to a status conference, filed a motion to withdraw the day before the next conference, and didn't show up to that hearing to even argue his motion to withdraw. That's why he was saying, well, all they want to do is take my money, so I feel like I have no choice.
So
I think
I'm going to interrupt you again. So by that, I feel I have no choice. Does that mean I have to go on and represent myself? Isn't that what your client's saying?
I believe, in a sense, he is saying that apparently I have no choice. But instead of the court saying, I'm going to give you more time or one final opportunity, it's clear to me that you are not at the same level as the other litigant. The court essentially just said, well, what's the definition of hearsay? And it's obviously you don't understand, but we're still going to proceed. I think that the answers that he gave to those questions as to, are you ready to proceed, always pointed to the fact that he was had moved toward obtaining another counsel, but he was just shut down in that response.
Mr. Caller, I have a couple of questions for you. First off, is this issue properly before us? Was this even raised before the district court?
He filed a request for pro se, of course, for a relief from judgment. He did not specifically state lack of counsel or bias or any of the grounds that are alleged here.
I'm sorry, did he move forward with that motion, or did that motion just kind of die on the vine?
No, it was heard and the court denied it.
Okay. And the next question I have is, in his motion to withdraw that was filed by Mr. Moreno, it says that respondent expressed that he wishes to continue to represent himself.
Correct.
So how are we to take from that he wanted counsel?
Well, he wanted to, yes, that's what the motion says, and it's obvious why, or apparent at least, why he wanted to represent himself, because he was disappointed in the case having taken a year and nothing had been done on the part of his attorney. But despite what that motion said, what he told the court during the trial reflected that since September, I believe it was 17 of 2023 to November 1 of 2023, when the trial was heard, he had contacted other people and he had made an effort to obtain counsel.
So how much time had passed between the status conference of that trial? Was it about a month and a half?
A month and a half, yeah. September of 17 to November the 1st, so about a month and a half.
Okay, so how much more time should be given? I mean, you asked that a continuance should have been granted, but he had plenty of opportunity. How much, where does the court draw the line so it can move forward with this case?
What we ask for is something that's reasonable and under the circumstances. The circumstances were really not explored. Here we're talking about somebody who would be going to an attorney's office saying, I have a trial setting a month or a month and a half from now. Can you represent him? And most attorneys are not going to do that. There's a language barrier, which means that he may have had to contact attorneys who can handle or take cases of Spanish speakers. That could be a problem. So a month and a half, well, that may not be a problem in a lot of cases. In this case, it clearly could have been. And it just to do a reasonable approach to the circumstances, I think reason would dictate allow a little more time, maybe another month, whatever's reasonable, but not just shut him down on, well, you just don't want to pay an attorney and not giving him information as to what would happen if he said, I am not ready. I don't want to proceed today.
Counsel, I wanted to tell you that your time has expired, but we'll continue and we'll just deduct any overage to your rebuttal. I did have a question for you. Basically, what relief are you asking for?
We're asking for a remand for a new trial.
Thank you. Any other questions, counsel? I mean, judges?
I have one other question. So I guess my point is that none of that was voiced to the court. As far as I've contacted somebody, I cannot find a Spanish speaking attorney. I've been told that they won't take my case because they don't have time. The explanation he gave was they just want to take my money. So what is the court to do? I mean, I feel like we're trying to go back in time and correct deficiencies for arguments that he should have made. And essentially it seems that ship has sailed because those arguments weren't made when they should have been made.
Well, he said more than just they want to take my money. He said they just don't want to take it because it's too complicated. And he tried to start explaining what the basis was for him not being able to obtain attorneys. But instead of allowing him to explain or further expand on it or ask more questions of him as to why he couldn't obtain counsel until then, he got shut down immediately. When he said, well, they think it's too complicated. The response was, maybe you are the one who's complicated. Maybe it's you. And that's also reflecting the fact that he was blamed for not appearing when either party had been appeared. And it was just kind of a situation in which the court was determined to argue against him and not accept anything he said.
The last question I have, I know we're short on time here. If you are asking for us to remand it, what is the legal authority for us to do that?
It's that the first trial was did not afford him due process. And in that, I would make a distinction between the right to be appointed counsel as opposed to just the right to have some counsel or at least a meaningful opportunity to obtain counsel so that fairness could be served, which is the purpose of due process.
Thank you.
Thank you, counsel. If you'll still have your, I'll give you 4 minutes for rebuttal.
Thanks, sir.
All right, Mr. Olson?
Thank you, Judge. Can you all hear me okay?
Yes.
All right, thank you. May it please the court. So Mr. Collar's been focused a lot on things that happened right before the parties went to trial on the merits. I would like to direct the court's attention to the status hearing on September 13th. At the very beginning of that hearing, the first question out of the judge's mouth to Mr. Alvarado was, so are you going to hire a new attorney or are you going to go forward pro se? His response, consistent with Mr. Moreno's motion to withdraw, was, I'm going to represent myself. The judge continued to give him all sorts of notices about what he can expect. He'll be beholden to the rules of Kansas Civil Procedure. And further, I think this paragraph is the most instructive as to why this gentleman had due process. The court said, if we go forward today, and if there is anything you realize later, after I made my decisions that you did not understand because you are not a lawyer, that is not a defense to the action, et cetera, et cetera. Do you understand? He indicated he did, and the judge had vouched for admonition in alternate way, saying if we go forward, meaning instructing him, he can ask for counsel if he wants. He just never took that step. They had a very similar exchange leading up to going on the merits of the trial on November 1st, before we got to that moment that Mr. Collar references of him saying, attorneys just want my money, my case is too complicated. Even after being sworn in, the judge asked him again and told him point blank, I do not believe you are prepared. Actually, I want to find it. All right. So you still want to go forward, even though I'm giving you the admission that you do not feel prepared to try the case. The judge gave him every warning, both explicit and implicit, that it's probably a good idea to hire counsel. Going any further is going to be essentially Judge Alvey practicing law on this man's behalf and asking for a continuance on his behalf, which is something an attorney could have done. He did have 6 weeks between September 13th and November 1st, which is a fair amount of time, even if an attorney decides to enter and then ask for a continuance, which most likely would have been granted since it would have been late in the day. This is not a complicated case. This is a pretty simple case of paragraphs. Mr. Alvarado knew about all the hearings. He showed up to all the hearings. He was notified of the risks and rewards. He took a risk. He lost. And now he's coming back and trying to say that it should be undone. I would like the court to notice that he never disputed any of the values that were brought up in the property division. He did not dispute the value of the home. He did not dispute the value of the $60,000 that he admitted to sending to Mexico of marital money. He did not dispute the value of the sum close to $60,000 he had in his own bank accounts. Ultimately, what he had argued and was given the opportunity to argue is that he believed that some $200,000 belonged only to him, and that my client should have been afforded the about $1,883 in her checking account and her $2,000 Pontiac. He indicated that was his position from the status hearing. There was an exchange where a judge asked him, sir, I intend to divide things 50-50. Do you believe that's correct? He said he did not intend to honor that. He had the same position by his testimony at the trial, but most importantly is he did not dispute any of these facts. And him having an attorney going forward, if the court were to remand the case, I can't imagine an attorney would be able to bring up any new numbers. These were never objected to. His only objections to the admission of evidence was that he did not believe she deserved it, not that they didn't exist. It's not that they weren't from the correct bank accounts, not the value of the home. Frankly, if we remand the trial and the court looks at the fair market value of the home instead of the county value, the home value is probably going up, if anything. Going back to due process, it is the opportunity to be meaningfully heard, but it is not the absolute right to counsel in this setting. I cited to 2 cases, one from the Court of Appeals, one from the Supreme Court. The first, I believe it's Humphrey. Give me 2 seconds. I'm sorry, judges. Hampshire, I'm sorry. Hampshire before the Supreme Court, and Kikarov in front of the Court of Appeals. In both of these actions, our courts found that due process was afforded to both appellants as they were both served with all the notices, with the petitions, with the summons. Neither one of them actually appeared to argue at their hearings. Mr. Hampshire was in jail, and Mr. Keeperov simply did not appear. He was in default, but our courts found that due process had been afforded to both of them because they'd been given all the paperwork and the opportunity, the window was open for them to participate in their cases, and they simply chose not to do that. Mr. Alvarado, in this case, actually participated a great deal more than both of those appellants. He showed up as he was directed. He presented his arguments. He even presented some evidence that was admitted over petitioner's objection. Which frankly, maybe even if he had the judge might not have given too much leeway. The court admitted a denied PFA, some photos of, I suppose, him arguing that my client kept the house kind of messy, and that was his basis for arguing the property should not be evenly divided.
I was going to ask you about that, Mr. Olson. What was the reason for showing a messy house?
If I look at the transcript, it appeared to be
Is that just, go ahead.
It appeared to be he was trying to argue that she was not cleaning as he expected her to, or that she was not chipping in as he expected her to at one moment in time. Of course, you know, we didn't get that included record on appeal, just going by the narrative in the court, but that essentially seems to be what he was arguing, that she wasn't helping and he had to do all this extra work. So in any case, you know, Judge Albee admitted it. She indicated that she would take it to give it the weight he assigned to it. Appears to me not enough to deviate from her kind of presumption of the properties.
I hope you don't mind. I'm going to take us back to that September hearing. I wanted to hear your argument, and then I want to ask, from what you pointed out to us, at the September hearing, status hearing, he advises the court that he will be appearing pro se, correct?
Yes.
So in those 6 weeks, he shows up at the November 1st hearing, pro se, again, advising the court, I tried to get an attorney and they just want to take my money as part of the works. And then they continue on. From putting yourself in the court's shoes, if you don't mind, would a district court from that September hearing and November 1st hearing get indication that Mr. Alvarado wished to hire an attorney?
No, because I believe, well, putting myself in the court shoes, I have to look at the actual words that Mr. Alvarado used, which is that I, as the hypothetical judge, had given him as much notice as possible, even in the layperson's terms, that if you don't hire an attorney, you might not like the result. I cannot take the next step and say, okay, we're going to continue this for you to do this. That to me is based on at least our case law. Then I'm practicing law on behalf of the litigant. So his actions, you know, speak volumes. He did not hire one when he clearly had the funds to do so.
Right. And the court can't force him to hire counsel. Is that right?
Yes, correct.
Thank you.
Thank you, Judge. It's my client's position, boiling everything down to a fine point. I don't believe that he would have been satisfied even if attorney had represented him. I mean, I can't imagine any attorney representing him in that moment would have been able to dispute any of the figures that he did not dispute. Judge Albee appeared to make a division of property based on the statutory factors of the party's apparent income, the party's ability to earn, you know, the lack of spousal maintenance despite a 15-year marriage, I guess honoring petitioner Ms. Castillo's desire not to seek maintenance when frankly she probably could have. There's a chance that, again, based on his positions, I just think he'd never be happy. And the right to be meaningfully heard doesn't mean the right to always get what you want. That seems to be what he really wants here. If we reopen the matter, I can't see it goes much differently. And frankly, based on the record before the court, more to the point, Judge Albee did not abuse her discretion. Everything seems to be down the middle. She notified him of that in the September 13th hearing. And then she did just that, but she gave him the opportunity to present his reasons as to why it perhaps shouldn't be, since that had been his position. And based on all those things, he did have due process. It looks like I've got maybe a few minutes left. I'd like to point the notice, or I'd like to address the issue of bias.
You have 4 minutes left, counsel.
Thank you, Judge. So it is clear that Judge Albee was frustrated with this gentleman, but judicial frustration is frankly not strange in family law, and it is allowed. Okay, the standard is that it cannot be deep-seated, essentially unfairness. I cited to Bolden, in which the 10th Circuit noted that judges can be frustrated, especially when they're showing frustration as to the lack of efficacy of one side's representation. And that's exactly what Judge Albee was doing, was implicitly communicating to this man, sir, you better get an attorney or else. It's not her fault. He didn't heed the explicit and implicit warnings. And further, Judge Albee probably had some reason to be a little frustrated with this gentleman on a personal level. She had ordered him to sell the house on September 13th, which he said he had no objection to. She ordered him to bring $60,000 of the money back that he really didn't object to. He just said he couldn't do it despite having 6 weeks. So he indicated that he had disobeyed, perhaps deliberately, 2 orders of the court, and then also essentially made an ad hominem attack, telling her that because she's a woman, she would not be fair. So I think she can be granted a little frustration, but again, most of her frustration was always geared towards him not hiring counsel and not clearly understanding the rules of civil procedure as an attorney might have done. And going any further is Judge Albee practicing law on behalf of Mr. Alvarado. So there's no bias there. There's frustration, but it's not indicative of bias. Everything else, if we take out the attorney piece, this is a very basic case. They had a status hearing in September. Court issued some preliminary orders. The court continued the case so that the parties could file taxes, so that the court could essentially be further notified of things relevant to asset division. They came back once the parties had done that, and then they had a hearing on the merits. When we look at it that way, he had every opportunity to do what the law affords him to do, which is to present his case, and he did that with or without counsel. Even if he had counsel, again, he probably wouldn't have been happy. So based on that, I believe that he had due process and this appeal should be denied.
Did you have anything further, counsel?
I do not, Judge. Thank you all.
All right. Let's then refer back to Mr. Caller. Let's see. Mr. Caller, you'll have 4 minutes on rebuttal.
In essence, what we're talking about here is that when Mr. Alvarado was questioned and admonished that he was in peril if he represented himself, he did not know, and it was clear that he did not know what the alternative really was for him, whether he was safe in requesting a continuance or whether that was available to him. I disagree with Appellee's position that for the court to have told him, we can grant you a continuance, or if you are not ready to proceed today, we would have to continue the case. That is not advocating for him. It is not practicing law for him. It's just offering him something that's available to make the parties or put them on an equal level. Going back to the statement from the record that was cited by the appellee, the question from the court was, so you still want to go forward even though I'm giving you the admonition that you do not seem to be prepared to try the case? He responded, what happens if I cannot find a lawyer? In other words, his response wasn't, yes, I'm ready to proceed, I don't care, or I don't need an attorney. His response was, what happens if I cannot find a lawyer? The court's response, and again, putting ourselves in the position of a judge, probably should have been, if you can't find a lawyer after I gave you an opportunity, then you will be forced to try the case yourself. But instead, the response was, you can find a lawyer, you just don't want to pay them. the court had absolutely no basis to say that. There was no evidence to that effect. And we are speculating as to what would have happened if he had an attorney that well, probably would have been the same. Maybe no attorney would have probably taken the case and so on. But really, all he wants to do is to have the opportunity to present evidence so that the factor number 5 in division of property is properly considered with evidence. Even if the result would be the same, he deserves the opportunity to present all the evidence on that factor, which is the source of the income and how money was spent. And there will be evidence. He attempted to introduce the marriage certificate, but what is reflected in the appellee's brief, the apparent purpose of that was not really to show the date of marriage. It was to show that on the certificate, the marriage certificate itself, it said that the parties agreed to keep property separate. Kansas law allows premarital agreements where the parties agree to keep the property separate. That would have been huge. It was not allowed. He didn't know how to do it. If another attorney were to take over, maybe there would be evidence to the effect that pursuant to that understanding, all those years, they bought things separately. That one was admonished to work if they wanted to make money, but refused to work for many, many years. All those things perhaps wouldn't make any difference, but it's evidence that he was entitled to bring forward, and he didn't know how to do it. As to the value of the house, yes, he didn't contest the value of the house. And if he had a basis to contest it, and appellee's brief itself recognizes that more than likely the value would be higher than the appraisal value. Yes, if the value of the house were to be higher, and the likelihood is that it's higher, that would have benefited him. In other words, if the court were to hold that the $60,000 were his property or was assigned to him, and therefore from that we do equalization, the higher the value of the house, the less he would have to pay. We have to remember that part of the order in the divorce decree was that he needs to pay an additional $23,000 based on the low value of the house. So at least that $23,000 he may not have to pay if he was able to present expert testimony as to the true value of the house.
Mr. Caller, you might want to sum up now. You've reached the
Yes.
end of your time.
Looking at the statements quoted in our brief, I think they do show that the court, unfortunately, for whatever reason, probably a personal problem with him, that sometimes attorneys come off as being antagonistic. Who knows what really happened? But the statements quoted in our brief show that the court was shutting him down at every opportunity instead of offering any meaningful way for him to present his case.
Thank you, counsel. Thank both counsel for your arguments here. Very well appreciated. We will take this under advisement and issue an opinion in due course. And with that, I think we'll end our recording at this point and say so long to